We've had equal pay legislation in the UK since around about 1970, when the Equal Pay Act was passed. And it took 5 or 6 years for it to come into force because there was a period when employers were adjusting to the Act, and that was a very successful period. And then around about 1975, the European Union, then the EEC, passed a directive on equal pay, which required the introduction of the principle of equal pay for work of equal value. So workers could compare themselves not just to workers of the opposite sex doing the same job, but to workers doing different jobs but work of equal value. That gradually came into UK law in the 1980s, made a big difference. But what has changed over the intervening 30 years or so since then is that collective bargaining has played less of a role in the implementation of the equal pay principle. That's partly because collective bargaining is less significant across the whole economy anyway, but also because of court decisions at the end of the 1970s that made it difficult to use collective arbitration mechanisms to adjust entire pay structures. So equal pay litigation is much more focused now upon the individual claim, but sometimes mass claims involving hundreds or maybe even thousands of individuals making claims. The civil procedure rules were changed in the early 2000s to make it possible for law firms to litigate on the basis of a no-win, no-fee. Now, this was difficult before. Now it's more straightforward. So there really was a new business model for law firms. They could identify potential litigants, in some cases people who were unhappy with what collective bargaining had done, and challenge collective agreements. Historical inequalities between men and women can be challenged before the court, even after an apparent compromise has been struck through collective bargaining between employers and trade unions. And this has meant a fundamental challenge through litigation to apparently established structures of pay determination through collective bargaining. This has proved very controversial because on the one hand the unions have said that the agreements which are being challenged reflect essentially a consensus between employers and trade unions, which deserves to be respected, but the litigants are saying these agreements themselves are discriminatory, discriminate against women, and do not adequately address past injustices. I think defenders of the no-win, no-fee law firms' approach would say they did actually produce tangible progress on equal pay. Defenders of their approach would say that they pressurised the unions in some cases into taking claims they wouldn't otherwise have brought. They also did have some spectacular victories for some of their claimants. Now, the union side would say, we were going to take these cases anyway, or we already had these mechanisms in place. And in some cases, the litigation has simply added to the costs of the collective bargaining process and slowed down agreement.
Well, I mean, we've now got 30 years history, really, of equal pay and negotiations and litigation. And when we first started, we were talking very much about using the legislation to bring employers to the table. And certainly a lot of job evaluation systems were introduced on the back of the employer's fear of equal pay challenge. So we started off, taking strategic cases so that we could actually negotiate fairer pay systems. I think as we went down the line and we actually arrived at the position where we had no-win, no-fee lawyers, and it became much more about litigation and about vulnerability because trade unions were being sued, and it wasn't just national trade unions, it was locally elected officials who were being sued, which, considering they do a voluntary job, it was a moment of crisis. I'm not sure it made a huge amount of difference to the number of cases that were taken because lots of cases were being taken anyway. I know today people were saying it drove unions into equal pay legislation, but in some ways it inhibited it as well in the way you could use it because you had to be very careful about who you were taking, what you were taking, the back pay issues that were discussed today. And, the fact that within negotiations you might even do things which might be statutorily vulnerable, but they were in the benefit, of the majority of your members. But then you had to look at the implications and the letter of the law. So it was inhibiting as well as being, possibly a driver.
There is a case for saying that what litigation has done, however, has been to bring some issues into the open and has actually helped to reduce the gender pay gap, at least in the public sector. It remains to be seen how the costs of litigation will play out in a period of recession and cuts more widely within the public services. We've really yet to see how that will play out. But I don't think that the outlook for equal pay is necessarily one of a widening of the pay gap. I think that there are strong legal pressures for a further diminution of the gap. But the progress that must take place in future has to be in the private sector. Now, that really won't happen unless we see more disclosure, unless we see some version of the pay audit principle being introduced in the private sector. I think also we have to see maybe some of these very innovative legal approaches that we use in the public sector by these highly innovative law firms, very controversial but no doubt very innovative. Can they do the same thing in the private sector? If it's the case that this worked effectively in the public sector, well, let's see them try it in the private sector too.